Hello everyone, and welcome to the July 2023 episode of My PIP Monthly. As always, my name is Amber Rouse Holloway, and I'm a partner here at our Troy office. Our July 2023 topics include a case law update. We'll be talking about two unpublished opinions today. First up will be the case of Spectrum Health Hospital v. Citizens Insurance Company, and this one was issued May 18, 2023. Then following the Spectrum Health case, we'll be talking about Robinson versus Kizota, and that's also an unpublished opinion issued April 6, 2023. And then for trending topics in PIP litigation, we'll discuss business auto policies and their effect on PIP benefits and potential motions for summary disposition when you have these types of business auto policies. And this topic will just be based on my experience in litigation when I have trucking cases with business auto policies and some issues that have come up in my experience. First up, the case of Spectrum Health v. Citizens Insurance Company, again an unpublished opinion that was issued May 18, 2023. Now this case centers around evidence being presented that the court decided was insufficient for either party to prevail on summary disposition as to whether the claimant's 2018 injury met the causation requirements of the No Fault Act to make plaintiff's treatment reimbursable. Now here, obviously this is a provider case that deals with a claimant's injuries and the provider attempting to recuperate on alleged treatment provided to the claimant. The claimant here is a Timothy Wolf, and he suffered a grade 3 AC joint separation as a result of a moped accident in 2018. Despite this injury, Wolf returned to work, thereby aggravating and injuring his shoulder on several occasions and ultimately elevating his injury to a grade 5 AC joint separation. And this was documented by imaging studies as well. Now, because of this grade 3 turning into a grade 5 when the claimant returned to work, the defendants prevailed in the trial court on summary disposition, arguing that Wolf's documented left shoulder injuries in 2019 and 2020, which occurred at work, required Wolf to use reasonable efforts to secure workers' compensation benefits pursuant to MCL 500-3109's governmental benefit offset provision. Now, just a little bit more on the background with this. There were two occasions in 2019 and 2020 where Wolf arrived at the emergency room following increased shoulder pain experienced while performing work-related tasks. Wolf's employer considered the 2020 incident as a near miss and failed to file any workers' compensation paperwork. And thereby, the defendants argued that Wolf's subsequent work incidents had aggravated his shoulder injury, serving as a causal link between the moped accident injury and the claimant's current condition. They also argued that Wolf failed to pursue workers' comp benefits, precluding him from collecting PIP benefits pursuant to MCL 500-3109, Section 1. Now, I won't read all of this, but essentially MCL 500-3109 came into effect here because the defendant maintained that there was no dispute who bore responsibility for Wolf's injuries, and they argued that Wolf was required to seek available workers' comp benefits, which would have been subtracted from any PIP benefits payable to Wolf by the governmental set-off provision right here. Now here, the Court of Appeals analyzed whether the trial court erred in granting summary disposition in favor of defendants on the basis that claimant's failure to use reasonable efforts to obtain workers' comp benefits. The Court of Appeals did find error on three specific reasons here. One, defendants could have pursued workers' comp benefits on behalf of claimant, citing this Algonac v. Harco case, which is also going to come up later on during the trending topics in PIP litigation section. And then two, whether the issue injury would have been covered by workers' comp benefits can only be decided by the workers' comp agency, which has exclusive jurisdiction pursuant to MCL 418-841, and 3, MCL 500-3109, Section 1 does not absolve a no-fault insurer's obligation to provide benefits. And thus, if a jury concluded that the injuries treated arose from the 2018 motor vehicle accidents, the insurers were only allowed to offset the workers' comp benefits as claimant was deemed to be entitled by the agency. So it's not necessarily a catch-all, this MCL 500-3109, like the defendants or the trial court sided with the defendants with. The Court of Appeals found that the evidence presented was insufficient for either party to prevail on summary disposition as to whether the subject injury in the 2018 accident met the causation requirements of the No Fault Act. And further, the Court of Appeals found reversible error in the trial court by holding that MCL 3109, Section 1, does not absolve insurers of liability of PIP claims. And finally, that the trial court lacked jurisdiction to decide whether the injured plaintiff or claimant Wolf would have been entitled to workers' comp benefits. Next up, we have the case of Robinson v. Secota. I'm pretty sure I'm saying that wrong, but this case was issued on April 6, 2023. And here it addressed whether a revocation of assignments allows a plaintiff to maintain a PIP claim filed prior to the revocation. And the Court of Appeals found that nunc pro tunc, a retroactive revocation, does not remedy a plaintiff's lack of standing at the time a lawsuit is filed. Now here, the Court of Appeals overturned the trial court's denial of defendant's motion for partial summary disposition, finding that the plaintiff was not a real party at interest when she filed the lawsuit. Further, the subsequent revocations did not remedy the fact that when her claim was filed, plaintiff had assigned her rights to pursue PIP benefits to the various providers, which we often see. Now, just a brief background for this one. After the motor vehicle accident, plaintiff, of course, accumulated bills from medical providers for her treatment. She assigned her rights to recover these benefits, to recover PIP benefits to several of these providers. Plaintiff then filed a complaint against defendant Smart to collect no-fault benefits. And then defendant moved for summary disposition based on plaintiff's lack of standing to pursue a cause of action to recover claims, as she had already assigned her right to collect to these medical providers. Defendants argued that the plaintiff's providers were free to file their own lawsuits to recover benefits should they choose to do so. Plaintiff then responded that these assignments should be treated as if they never existed, since after filing her complaint, she executed mutual revocations of assignments with several providers that revoked, rescinded, and nullified the assignments nunc pro tunc, or in other terms not Latin, retroactively. The trial court denied Smart's motion, in part holding that Smart did not have the authority to enforce plaintiff's assignments, and that those assignments were in fact revoked, and this appeal followed. Now, ultimately, in the opinion, the Court of Appeals analyzed the term nunc pro tunc has been used in licensing assignments and federal patent and trademark decisions, but not typically here. The court noted, or here meaning in situations such as this, the court noted that in several cases, nunc pro tunc assignments do not cure a standing defect, and a party filing suit must have had standing to sue at the time of the complaint. So essentially, when the revocation occurs after the time for performance matures or the rights of parties become fixed, mutual revocation of an agreement does not return the parties to status quo as if it existed prior to the assignment. And because the rights of plaintiff vis-a-vis defendant and the court had essentially become fixed under the assignment of agreements, the revocations could not impact plaintiff's statements or plaintiff's status at the time the complaint was filed. Now, the Court of Appeals applied that same logic explaining that the plaintiff must be the real party of interest when a lawsuit is filed. The court further opined that executing a nunc pro tunc revocation, though creative, does not correct a factual issue that existed at the time the lawsuit was filed. And moving on to trending topics in PIP litigation, I wanted to discuss business auto policies and their effect on PIP benefits and potential summary dispositions. Now, with these specific policies, as we all know, the No Fault Act controls. However, a policy can add additional benefits, can expand upon benefits to a plaintiff or a claimant, or the insured rather, in this specific instance. So you must look at the forms in the endorsement schedule. and the coverages that apply. So a lot of times in these business auto policies, coverages only apply to specific vehicles, and that vehicle must have been used in the accident itself. A lot of times you'll see situations where a company has a fleet of vehicles, but for some reason was not using the vehicle that was involved in the accident, but still tries to claim PIP benefits as if they were using the vehicle, when PIP benefits does not apply to that specific vehicle, but the vehicle is insured under the policy, but just not for PIP coverage. And that goes to the covered autos or specifically described autos. So specifically described autos only receive specific types of coverages, and covered autos only have specific types of coverages as well. Just because a vehicle is listed on the policy does not mean it has all the benefits available to it, or all of the coverage rather available to it. Now, MCL 500-3114 Section 1 determines the order of priority, as we all know, and then it was reformed in June of 2019, and the statute now provides that an injured party must first look to their own insurance policy, then a spouse or resident relative, and lastly to the Michigan Assigned Claims Plan. Now, in situations such as we see with business auto policies, MCL 500-3114 Section 3 will likely control if the person seeking benefits is an employee, his or her spouse or relative either domiciled in the same household, who suffers an accident or bodily injury while an occupant of a motor vehicle owned or registered by the employer, and that person shall receive PIP benefits to which the employee is entitled from the insurer of the furnished vehicle. Now, as you see on the slide, I have some underlined and italicized terms. So that's the owned and registered. A lot of times I've seen situations where the involved vehicle was not owned or registered by the employer. It may be a situation where there's a subcontractor or a W-9 employee and not an actual employee. And therefore, because they're not an actual employee, they own or register the vehicle and not the insurer, the named insured on the business auto policy. And when you have that issue, then you might have to do this test, what I describe here as the economic reality test, and that is from the case of Aldenac v. Harco, as discussed in that very first case we talked about today. Now, by this test, the factors to be considered, and this is not an exhaustive list of factors, but these are some that the court talked about in the Aldenac case. Control of a worker's duties, payment of wages, right to hire, fire, and discipline, performance of the duties as an integral part of the employer's business toward the accomplishment of a common goal. Now, and you find these answers out during the plaintiff's deposition. You ask how their typical day would work, who gave them their assignment or their work duties, did they pay their own taxes, did they work for themselves, or did they have a boss, did they make their own schedule? So it's not an exhaustive list, but the more you have in your favor, the better you will be for a motion for summary disposition, as arguing that the policy or arguing that the plaintiff is excluded from PIP benefits because they're not covered under the policy for whatever reason. Likely the vehicle isn't owned or registered by the named insured, or the vehicle is not scheduled on the policy or not covered on the policy for PIP benefits. Again, this slide essentially states that this is not an exhaustive list, so no single factor controls. And that is all I have for you guys today. As always, thank you for attending the July 2023 episode of My PIP Monthly.